days or so, he's used marijuana. Typically, that's how long. Which means that he used marijuana after he pled guilty on. He pled to an enhanced sexual degree. I've got pages of criminal history here, and you would think, Mr. Spite, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you wouldn't, number one, go to prison. I don't even have to accept a plea. I mean, you've got 3 prior convictions, a state jail felony from 2019. I mean, yeah, 2019, credit debit card abuse in 2021, and then an unlawful possession of a firearm in 2022. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to.
And right out of the gate, this is brutal. Testing positive after pleading guilty on a felony? That's not just bad timing. That's legally catastrophic timing. When a judge sees drug use as close to sentencing, it screams one thing. You're not taking this seriously. And remember,
get you on the right track. And Ms. Hawkins did a great job of getting you probation offer on the cases. Yeah. And I appreciate that argument that Ms. Hawkins made, but it's also important, and I would hope that other judges in other counties would find it just as important that if you're going to get charged, wherever you're going to get charged, that they take into consideration that just because you didn't steal from someone in our county, you stole from someone in some county, right? And so we got you here, but somebody's a victim. And it's important to me, and hopefully important to every judge in the state of Texas, that we kind of look out for each other in each other's counties. So I get that you were just traveling through. Probably lucky that we got you, because who knows what would have happened at that point if you ever would have gotten caught. And that's not fair, no matter what county the crime actually is. Does that make sense? Based on everything that is being offered to you and what the pre-sentence talks about with regard to drug usage, the only way I'm going to go forward with this is with inpatient ISF up front. So,
this is a first-time offender. We're talking enhanced second-degree felony territory. That enhancement, it changes the entire sentencing landscape. Question for you. If you were the judge, would this test alone shake your confidence in giving probation? Did you catch that? I don't even have to accept this plea agreement. That's judicial code.
Not necessarily meant to be a punishment. It will probably feel like it a little bit, but if you're going to be successful in the rest of your life, be there for your children, then you got to figure out how to stay clean and make some other decisions. So that's going to happen. Any reason not to move forward with anything? What are the court? Are you representing on the court bench? And what about the Harris County? Is that abating? Just don't. Hmm. Trying to think of logistically, because I mean, one thing that I can do, I'm just not inclined to let Mr. Fights work out today on probation when he tests positive with this kind of history, with technically 4 felony cases in 3 different counties. So, no, no. And so, what I'm going to do is I'm going to order it. And then once he's in custody, have you'll let obviously the county know that he is in custody. And if they will put a hold on him and get him, I'll release ISF hold while he goes into jail. Same thing with court then. Then if those are going to be probation or whatever happens, we'll put our hold back on once he's gone. So that when he finishes those counties, we still got him. Sometimes.
For you are hanging by a thread. Plea deals aren't automatic. The judge has to approve them. And with 3 prior convictions and no history of probation success, this offer is looking less like mercy and more like a final experiment. The court is basically saying, convince me you're worth the risk. This is a powerful moment. The defense is arguing technicalities, jurisdiction, no restitution owed locally. But the judge zooms out and reframes it morally. A victim is still a victim, no matter the county line. That's
what happens if that process takes a really lengthy time, then potentially, if I feel like it's good enough time, then I can hold that at abeyance at that point and require like JCI with the outpatient. But based on the positive drug screen today, based on the criminal history of it all, he's not walking out today, so we'll do it that way. If you'll get with his attorney in Fort Bend County, the sooner they get something set and get a hold on him, the better. Okay, that way he can get transferred. Perfect. Something quickly. So, Mr. Spice, I'm going to find that you previously pleaded guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with.
Now we see the balance the judge is trying to strike. 5 years probation, no restitution for mandatory inpatient ISF. On paper, that's lenient. In reality, conditional mercy. The court is giving him a chance, but only inside a tightly controlled structure. Do you think this is accountability done right, or a setup that's nearly impossible to serve and review?
And defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine. There is no restitution, and you're ordered to ensure successfully complete. Mr. Spice, talk to her in a minute. Just listen to what I'm saying, okay? You're ordered to enter and successfully complete the substance abuse track of the ISF program. And if you do all of this, this is a great opportunity. I know it doesn't feel like it today, but you have a great opportunity.
Subtle but important legal philosophy. Courts don't operate in silos. And this judge is signaling something bigger. Accountability travels with you. Do you think courts should factor in harm outside their own jurisdiction like this? For pending felony cases, 3 counties. This is no longer just a drug issue. This is a pattern issue. Judges look for patterns more than isolated mistakes. And when multiple jurisdictions are involved, coordination becomes a legal chess match. Notice how the judge immediately starts thinking logistically about custody holds and transfers? That's courtroom triage. She's making sure no county drops the ball. This is justice system choreography.
In this case, number 1, without another felony conviction, and to be able to serve anything on probation. I wanted you to make sure you understand, though, what the consequences could be if you violate this probation. So, if you choose to smoke marijuana again, or not show up for an appointment, whatever it is, then you're looking at not just the sentence of capture property, which is a 3rd-degree felony. You pled to an enhancement, which means if you violate, you can be found guilty and sentenced to prison for anywhere between 2 years and up to 20 years. So I'm trying to keep that from happening and give you some tools so you can do that. I'm handing you the trial court certification that shows this was an agreement. I followed it, and so you've waived your right to appeal. You can.
That's where ends, with a warning that goes louder than the sentence itself. Mistake. And this case explodes from probation into 2 to 20 years in prison because of that enhancement. This isn't just about marijuana, it's about trust, patterns, and whether this really is a second chance, or the last stop before prison. Drop your thoughts below, Judge. Make the right call here.
Go back to the bailiff and talk with the physical. Okay? Yes, sir. We're going to let them know that you're in custody, and they'll come transfer you over there from our custody. Miss Hawkins can explain it to you, okay? All right, you can go back with the bailiff. Thank you.